In the name of Allah, the most gracious, the most merciful. Ladies and gentlemen, peace be upon all of you. Let me at first thank the conference committee for accepting the paper to participate in this valuable international conference on applied linguistics. Second, allow me to tell you that I'm so delighted today to be among you here to talk to you about the impact of legal English idiosyncratic syntax on the readers between psycholinguistic dilemmas and preciseness, theoretical study on EFL context. Generally, legal language is said to be dry, frozen, and incomprehensible. Legal English particularly is armed with an array of idiosyncratic characteristics, especially at the sentence level. This is because of the unusual nesting of clauses within one sentence without giving any consideration to the readers. The main issue is, could these syntactic complexities cause some reading interruptions? Could those complexities then cause psycholinguistic problems as declared by Hovelso? Or are they also meant to promote preciseness like Bahatia's views? Could the plain English movement moderate those complexities? If so, could it preserve the degree of precision? The aim of this study is to contrast the two opposing views, to take into consideration the plain English movement and how it might realize a balance between the two opposing views. In fact, the syntactic patterns of legal English received considerable attention. Here are some examples on which the study concentrates the most. Qualifying and periodic clauses. As you see in the excerpt, the act starts with a hypotactic structure carrying some qualifying information. Then, the subject and the verb interrupted by another adverbial before reaching the main clause that carries the main idea. The order is similar to the famous formula, if X, then Z must be Y, mostly used in legal English sentences as stated by Crystal and Davy. The main idea, put at the end, is so short compared to all of those qualifying clauses. The second excerpt shows the irregular placement of adverbial clauses. The sentence is overlong because of the insertion of many subordinations that interrupt the main clauses. The alternative order with blue and black show how many syntactic boundaries at which the qualificational and main clauses alternate. Even the verb phrase shall supply is interrupted. Scholars held different views as to the reasons of the complexities found in the syntactic instructions within legal English discourse. Some researchers on legal English, such as Hovelso, believe that this situation caused unjustified psycholinguistic dilemmas to the readers, letting their heads spinning. Others, like Bahatia, think that those complexities are needed for precision in that legal drafters insert qualifications right next to the word they are meant to qualify. Crystal and Davy relate them to style and elegance, but all of them agree that those complexities make way to the inescapable consequence of difficult reading, then limited understanding, and thereby poor application of law. Reflecting this situation of real-life use of language, the poor application of law will negatively affect many sides such as economy, politics, environment, urbanism, industry, and judiciary, as these areas are mainly based on international rules. This is why the plain English movement has been established. According to Carlo, the modern plain English movement began during the 1970s, thanks to David Milenkoff's The Language of the Law, which gave birth to many reforms all around the world, promoting a simplification of legal English. Goddard, for example, set some rules to simplify legal English. For example, making concise sentences, focusing on one idea with subject, verb in active form, plus object. The main idea comes first, then avoiding long sentences, subordinations, and embedded clauses. Putting the previous issue within plain English movement framework might offer good impacts. Going back to the first complicated excerpt, Hovelso thinks that how much simpler it would have been if the writer had organized the text in such a way that the sentence begins with the main idea, and all the case descriptions, as Bahatia put them, are to be put at the end. In practical words, Al-Farahati confirms that current legislation has recently begun to take into account the use of simpler language, but one can question the possibility of simplifying semantics found in international documents such as Article 24 and the United Nations Convention for the Protection of the Mediterranean Sea against Pollution. The density of the adverbials and syntactic repetitions makes it impossible to reorganize this excerpt, such as in saying, in the Conference of Plenipotentiaries of the Coastal States of the Mediterranean region on the protection of the Mediterranean Sea. As you see also, there is in Barcelona, in Madrid, in Barcelona, and so many adverbial or prepositional phrases. Anyway, simple legal English will decrease the psycholinguistic dynamics and conserve the preciseness and elegance. This allows for a comfortable reading that itself offers a full understanding and, as a result, a good application of law. Again, reflecting this situation of real-life use of language, the good application of law will positively affect the sides mentioned before. These are some implications for this study. First, there is an urgent need to conduct more theoretical and empirical studies on the unique style of legal English, especially when related to an EFL context. Second, ESP/EFP teachers must develop their learners' reading skill in English for low syllabi. Third, teachers also have to join plain English movement by opting for adapting or designing in-house legal English materials whose linguistic content is simple. Doing so, the ELP course designer needs to strike a balance between the needed structures for preciseness and the decreasing of the complexities and the psycholinguistic dilemmas. Finally, students' motivation must be fostered to adopt strategies to process any faced ambiguity well. In conclusion, this study is of central importance in that it offers insights into the very complex nature of legal English syntactic structures. It shows the impact of those complexities on EFL learners' psycholinguistic and cognitive sides. It also discusses the plain English movement. Then, it is recommended to merging both theoretical parties by establishing a middle ground, implementing ELP course design that offers EFL law leaders a secure command of legislative documents, developing EFL law students' leading role in life, as this concerns the language of international legal practice and the era of globalization. Thank you for your attention, ladies and gentlemen. Feel free to ask any question.